Hi, everybody, and welcome to this month's Facebook Live. This is Carrie Payne on behalf of the Art of Estate Planning, and I'm joined today by Amanda Little. We've been so blessed to have her join today and talk to us about the intersection between family law and estate planning. We're going to swap to Amanda in a moment, but I just want everyone to let me know if you can hear me in the comments. Say hello, let us know where you're dialing in from, what you're most excited about hearing about from Amanda today. I will let you know, obviously, Amanda's got a set presentation, and you can certainly send your questions through, making sure that we've got plenty of things to keep her busy. In terms of any questions that might take a little bit more time, we might have to take those offline if we can't get a chance to get to them. But Amanda, without further ado, I'll hand over to you and let you take it off.
Thanks, Kerry. I'm super excited to be here today. So for those of you who don't know me, my name's Amanda Little. I have a firm called ALA Law, also previously known as Amanda Little and Associates. And I also have the Family Law Education Network of Australia. A lot of you may or may not be smoke ball users. If you're a smoke ball user, you would see me on all the CPDs there. So I'm really actually excited about today because I'm a bit passionate about the interplay between family law and estate planning. And I spend a lot of time talking to people about how estate planning includes so much family law. So estate planning lawyers are really good at understanding tax implications and trusts and all of those kind of things. But often the family law side of me wishes that estate planners also knew a little bit more about family law. So I'm going to take you through some stuff today, and hopefully you learn something from me. Ask questions as we go. I love to be interrupted. So interruptions is not a problem for me. And I also tend to not script anything. So I have some PowerPoint slides, but it's just to trigger me as I'm talking. So feel free to ask any questions as you go. So personally, I'm an accredited specialist in family law, and I've been practicing in family law for 20 years. And I'm also a mediator, an FDRP, an author, a lecturer at university, a public speaker. So I love to meet new people, and I love to engage in these kind of online sessions with other lawyers because I find it really valuable. So please disrupt me at any point and ask any questions that you may like. So basically today, what I'm going to talk to you about is how the two areas intersect each other. And it's in so many different ways that they interplay with each other. And as I was putting together this presentation, I was actually talking to my colleagues, and I was like, it was very hard for me to get everything that's in my head in an organized order to actually take you through bit by bit. So I'm going to break it down into a series of different discussions today, simply because I'll then be able to work through them item by item. Now, in the estate planning process, the interplay with family law is not just from the very beginning, but it's all the way through. And it's not just about how you draft your documents. It's also about how you plan other estate planning, like how you use other estate planning tools, such as like property law and things like that, to assist in the client's desired results in the estate planning process. So I'm going to talk to you about these things here. So the first thing I'm going to talk to you about is previous relationship breakdowns and new relationships and what that means from a family law perspective. So we all know what that means when we talk about it from a estate planning perspective. But I'm going to explain to you how that actually works as a family lawyer, when to trigger your client to see an estate planning lawyer if you are not also doing estate planning, and as an estate planning lawyer, when to trigger your client to see a family lawyer if you don't practice across both jurisdictions. I'm going to talk to you about asset holdings and risk. So some of the things we do as an estate planning lawyer, family lawyers die inside with, because we know that puts the other aspects at risk. But then at the same time, as someone who does both, I know it's a balancing act, and we're moving pieces around on a chessboard to achieve the desired results. I'm going to talk to you about asset protection pre and during relationships. So not just your prenups that you hear of, but what we call cohabitation agreements. Then I'm going to talk to you about asset protection after separation. So how and what we do for a property settlement and how that interplays with estate planning. And then the last three are going to be the ones that I'm going to really enjoy discussing with you, which is the forced separation position in relation to asset protection. So when, for example, you have an elderly couple who are separated not by choice, usually illness. I'm going to talk to you about kids, and then I'm going to talk to you about litigated matters and how that works in relation to loss of capacity versus death, and what options are available as you may or may not get clients. So this kind of will cover so many different and variable aspects of estate planning, and will also not just be about the preparation of materials, but also if you're helping a family in the process of using the documents that you've got, how you can direct them in the right direction at the time that these things happen. So, ready? Here we go. All right, so the first thing we're going to start with is the previous relationship breakdowns and new relationships. So I base mine all on New South Wales, and each state will be different, but this is my area of practice. So we all know these things, but I'm just going to run you through them for very basics. So when you're preparing your wills, you need to make sure that you understand as a family lawyer that when somebody gets a divorce, there's a partial revocation of previous wills, and whether or not a new will need to actually be put in place based on the beneficial disposition to an ex-spouse or appointments which are partially revoked on the making of a divorce. So that one's nice and easy. You can, of course, do your in contemplation of divorce and in contemplation of marriage in each of your wills, which will bypass the Succession Act. Pursuant to that act, you are able to actually put in specific clauses, which mean that on either divorce and or either the marriage, that it doesn't necessarily automatically invoke the relevant sections of the Succession Act. So we're all across that, and I'm not even going to go into that in depth because I'm sure that's something that everybody automatically knows. And as a family lawyer, one of the things I do when I'm assisting someone with a family law matter is if I'm actually looking at assisting them with a prenup because they're going into a relationship or they're planning on getting married, I will automatically tell them about the relevant estate planning aspects of that. And so as an estate planning lawyer, what you would do if they're going to tell you that they're going to, they're planning on getting married, is that you would say, okay, I'm going to deal with that in your will by putting, for example, in contemplation of marriage, so that we don't revoke the will that I'm currently doing if your intention is for it to continue after marriage. And then you would say, but I need you to go and see a family lawyer if you want to do something like protect assets. And that's where we talk about the prenuptial agreements. So in kind of any estate planning context, when I see a family or I see a couple who are, just getting together and they're looking at merging assets, especially second and third marriages where there's adult children to previous marriages, when we estate plan, we don't just look at, who gets what on the death of the other party or who makes decisions on loss of capacity. We look at what assets we want to quarantine, in essence, what assets we want to make sure goes to which side of the family, or whether or not we want to combine them to provide protection. And we talk about what the goals of that couple unit are. And then we work through the different types of jurisdictional options. So not just your will, but are there some property options that are available? Is there a prenuptial agreement that might be available for that purpose? And I'll take you through that as well a bit later in the discussion. Also important to keep in mind that your power of attorney and your enduring guardian are not revoked on divorce. So as a family lawyer, and if there's any family lawyers attending today, it's really important to say, you need to go and see your estate planning lawyer, because those documents that were in existence continue to be in existence. Your POA is not revoked on marriage, and your EG is revoked on marriage. So there's different rules depending on each. So the importance of it with the interplay with family law is basically a lot of clients think in family law that once you get a divorce, that's the end of your relationship with each other financially. They don't actually realize that there's still it doesn't automatically revoke a lot of the estate planning tools that they've previously engaged lawyers to prepare. So as a family lawyer, you need to know that that's what it doesn't do. And as an estate planning lawyer, if someone comes to you and says, I'm separated from my husband, you need to know that they need to be sent to a family lawyer to deal with a property settlement. They need to be sent to a family lawyer to deal with, a cohabitation agreement if they're getting together for the first time, so that you understand at what point you need to trigger the advice of another lawyer.
Amanda, just while you're having a breather there for a second, I thought I might catch you. Just so that, because we've got everyone of different levels of experience in the group, both in our group, and I know you're going to be sharing this with your own family law network.
I am, yes.
So I appreciate this is a stupid question for the family lawyers listening. When you say terminology like prenuptial agreement and cohabitation agreement, they're all just other terms for what we would call the binding financial agreement. Is that correct? They're just sort of at different stages of that process, or?
Yes. So the legislation in the Family Law Act sets them out and names them cohabitation, and post-separation. Generally speaking, most lawyers call them binding financial agreements just generally as an umbrella. From a consumer perspective, they call them prenups because that's what they're used to seeing on television. So the use of those words are completely an interplay based on people's knowledge and understanding. So you're absolutely correct. They're all binding financial agreements. And the type of agreement and the section they're made under the Family Law Act depends on whether or not they're married or intending on being married, or if they're de facto, as they're different sections. So you're correct. Yes.
Great. Yeah, no, good to know. I hadn't never really drilled down into the exact names for them. So
I will I'll take you through what each of them are as we get to them. But essentially, one of the misnomers is, especially with binding financial agreements, so the ones prenups, what Americans call them, and a lot of people will walk into my office as a family lawyer and say, I need a prenup, is that they're actually not as binding as people think, and they're very easy to overturn. And although people seem to think that they're this amazing shield that can block claims, there's very few circumstances where there's certainty in that BFA. So I'll actually take you through that today. It's one of the law cover talks about the fact that when you go and do law cover training with them, binding financial agreements are one of the main reasons family lawyers end up with claims and suits against them, because they're actually so risky to do. Yeah.
Wow.
So
okay.
I think a lot of people think it's like a golden bullet that you've got that will protect you, and in some cases it is very helpful. So your second and third marriages with equal, if people come in with like equal asset holdings, and we don't have ESLs or people with English second language, we don't have, one with an extremely high earning capacity and one with not. So when people come in on an even keel in second and third marriages, they're a lot more secure. The older you are, the more secure they are. The younger you are, the less secure they are. The longer you are together, the less binding they are, and more likely they are to be overturned. So as a family lawyer, when I get sent a prenup request or a pre-financial agreement, we spend a lot of time talking about the utility of it based on that person's circumstances, as opposed to just the general law, because it is like a sliding scale of utility, would be my best description.
Thanks, Amanda. Sorry to interrupt.
I love it. Interrupt as much as you like. So the next thing we always, I like to talk to my clients about when they come to me for estate planning is this idea of asset holdings and risk. So one of the tools in estate plannings that we often use when we get out our tool belt is the idea of, do we need to move asset holdings for the benefit of a spouse? Do we need to make them joint tenants so that it passes on survivorship? Well, we all know in New South Wales, unfortunately, we have notional estates. You have to survive your period of time once you do something like that. But it's something that I like to talk to our clients about, because the appetite for risk when it comes to family law and moving asset holdings is very interesting. So as an estate planning lawyer, if I was talking to somebody about, putting a spouse, am I back? Can you see me?
Yeah, I think you're back. I think I was worried it was me and not you.
No, it was me. I'm so sorry. We have no internet. I've just moved offices and NBN has not connected us, so I'm hotspotting off my phone. So apologies.
Oh, good, I've got you now.
So if someone comes and sees me for estate planning purposes, what I'm often talking to them about is simply how do we secure, for example, housing. So a really common example is second or third marriage come to me. They both have children from previous relationships. Wife might have a house, but she wants to make sure when she passes away that the husband is able to continue to reside in that property. So we might talk about the different options. You might talk about, do we create a right of occupancy? Do we create a life estate as a proprietary interest? Or do we put him on title because there's stamp duty exemptions to get spouses on title, so it passes by survivorship? There's lots of different ways that you can look at dealing with that issue. So if the client comes to you saying, well, we've decided we want to go on title together, so it passes by survivorship, we then need to look at it from a family law perspective, because that may achieve the desired result from an estate planning perspective, but what it does then is it may upset the status quo in relation to family law. Now, under the Family Law Act, it doesn't matter whose name an asset is in, because it's all considered to be part of the pool. But there are some exceptional cases and in some circumstances when if you do not intermingle an asset in the asset pool, one can argue it should be quarantined from the asset pool. These are very rare circumstances. It's usually things like inheritances that are received and placed into a trust at a later date and never intermingled with the other assets of the relationship and things like that. But when you start adding people to asset holdings, making things joint, it might be, for example, we put him on the title and he joins the mortgage and there's a redraw facility available on the mortgage. And if they do separate, he puts his hand in, takes the money out of the redraw facility. There's lots of like issues from a family law perspective, which could have been mitigated by not adding him to the title and not adding him to the mortgage. So when we talk about estate planning, we talk about all the different things that we can do to achieve the results on death or loss of capacity. When we talk about family law, I'm unfortunately looking into my crystal ball and trying to work out, does this couple look like they're going to make it? And, you know, working out how do I minimize the risk to my client if they're not the same people, and then that's another interplay altogether. But how do I minimize the risk to my client to maximize the likelihood of their asset being protected upon breakdown of the marriage or relationship? So it's like I said, it's like a chessboard. And when I'm seeing somebody, because I have a family law brain on one side and estate planning brain on the other side, I'm often thinking about how do I also mitigate the risks in relation to an estate planning perspective. Another common example would be, let's say you have a widowed wife and she has a property and she has 2 children, and one of the children has significant issues, has no relationship with her at all, and she has one child who looks after her and she wants to ensure that that child gets the property. So someone without a family law brain will go, oh, well, maybe we'll just add that child to the property as joint tenants. As long as she lives for 3 years in New South Wales, when she dies, it will pass via survivorship, won't form part of her estate, can't be contested. But my family law brain says, well, if you put half of that into the child's name and the child and their spouse breaks up, then that forms part of their asset pool for division, which means provision will need to be made out, which then means my client may lose their house because there's no ability to pay out that interest. And even though it's what's called a Section 79 adjustment, and I'll take you through what that means, even though it's an adjustment because it's a contribution, but for the gift of the half of the property to the child that wouldn't exist in the pool, your client gets pulled in and becomes a third party to family law proceedings. So when we're talking about not just spouses, but we're talking about children and how that works and the interplay in family law, we're also considering if we're doing something to try to keep an asset out of a pool available to be contested under the Succession Act or the relevant legislation in your state, what effect does that have if we're putting it in somebody's name or sharing with somebody who has a spouse and children to another relationship? So just another level of complexity on top that I worry about regularly when people are saying, I want to put my daughter onto title so that she gets the property. So I'm not sure, Kerry, if you've heard that and people have come to you and spoken to you about that, and that's something that you might have canvassed with them previously.
Yeah, it comes up frequently. I am holding back a question in case you cover the topic already, but I've seen time and time again where an inheritance is potentially brewing and the child is entering a new relationship, and can we somehow, other than actually putting it into a testamentary trust, is that the only protection we can give to that child entering into a new relationship?
Yeah, it's very interesting because, under the Family Law Act, which I'm sure you've heard this before, everything is in, basically. Even if it's in a testamentary trust, it's still the case law is still, it's case by case basis. And a testamentary trust or a discretionary family trust in itself is not a full protection mechanism. So the court can still consider that. So it can either put it in the pool and then give an adjustment under Section 79, which is a financial contribution, or if it chooses not to put it in the pool for division, it's then counted as a financial resource and is adjusted against under Section 75(2) or the relevant 2.0 it is, or the relevant considerations for a de facto relationship. So it's really interesting because even if you manage somehow to not have it in the asset pool, it will still be taken into account because you have access to that financial resource. And so that'll be adjusted accordingly.
Just to clarify too, Amanda, when we're talking about everything is in, is it the case that everything is in, including potentially a testamentary trust or an existing family trust, and then it's that person's responsibility to prove that it's a financial resource rather than an asset to be divided? Or who makes that call? Like, who has to provide the evidence?
So usually the person who doesn't want it to be in will be the one saying it shouldn't be in, and then there's usually a fight over it. Ideally, the best way to do it is it would be in a trust that is a discretionary trust with multiple beneficiaries and not a guaranteed interest and not controlled by the person whose interest is in question. So it basically has to be an arm's length trust that's created specifically with multiple beneficiaries, which you're not necessarily entitled to anything in, for it really to be something that the family court's going to say, well, we can't really take that into account because A, they have no control, and B, they may get absolutely nothing. So Tara's asking questions.
Yeah. So for those that are listening and can't read, Tara's put down a question that she's thought that if there is a testamentary discretionary trust, that shifts the onus back on the person trying to prove that it is an asset that's able to be divided rather than just a financial resource.
So the answer to that question is yes and no. And this is the problem with the family law system, is that it's completely grey and every case is case by case. And so you will find precedent that says that. And then you will find precedent that says the opposite. And then you will go in front of a judge who has a completely different opinion again as to how it works. What I will say is this, is the receipt of an inheritance into a testamentary trust, if that trust is for one person, does not protect that trust. It doesn't mean it forms part of the asset pool, but it becomes a financial resource. So there's what we call like an adjustment to the other party because you have access to that testamentary trust and the ability to use that trust. So even though it may not form part of your asset and liability pool, there is an adjustment that is made because you have that financial resource available to you. So for clarity,
Amanda, when you say an adjustment is made, is it that they then get less assets that are capable of being divided? Can it end up ever that if there's not many assets to be divided, that they owe that other person money?
No,
because of the financial resource?
Yeah. So basically, it generally means what ends up happening in a very rare circumstance is that one party gets the majority of the pool. And it's all, this is the problem with family law, and anyone that delves into family law that hasn't done it often really struggles because there is actually no rule that applies to any one thing. And I know we talk about, I'm sure you've heard about family lawyers talk about the 4-step approach, which is identifying the asset pool, looking at the 79 contributions, which is your financial and non-financial contributions, looking at your future needs, which is what's called your 75-2 factors, or your equivalent for de facto, and then just an equitable division at the end. So once you've done all those things where it falls and then seeing if you need to adjust again, that's all even contingent on the size of the asset pool. So to give you an example, like if you have an asset pool of $200,000 and you have an inheritance sitting in a testamentary trust of $350,000, that's a significant financial resource compared to the size of the asset pool. So what that means is that the court's going to say, well, you have access to that money, depending on how it is controlled and how it's set up. And the court's going to adjust because they know the other party doesn't have that financial resource that's available to it. And so from a family law perspective, when we're negotiating settlements, what an estate planning lawyer has done in the drafting of documents can make a huge difference to how the asset pool plays out and how the division is affected in a family law property settlement. Yeah, it's very, very, it's a tricky situation. So as a family lawyer, what I'm looking for when I'm doing a property settlement, so from a family law only perspective, what I'm hoping is if it wasn't in a testamentary trust or discretionary testamentary trust that was created, that it was never intermingled. So what I'm hoping is that my client got $500,000 and my client put that directly from the solicitor's trust account into an independent term deposit and hasn't touched it since. And when I talk about intermingling of that, what I want to do is I want to make sure that they haven't used money from that inheritance to pay things, or they haven't put that inheritance into a joint account before they transferred it out. Because once we intermingle it, the very rare ability to argue that something should be quarantined disappears. If I'm able to quarantine an inheritance by arguing it has never been intermingled, and there is case law that talks about non-intermingling of a quarantined inheritance, then I can argue that it shouldn't be on the balance sheet. It should just be a financial resource that's adjusted. So it's sometimes, just to make it a little bit more complicated, I run two balance sheets. I run one with it intermingled, so everything in, and I run one where I quarantine it and then I adjust it. So on the first one, my client gets the 79 contribution for introducing the inheritance. And then on the second one, my client loses out on 75 too, because they've got that financial resource. And sometimes, depending on the size of the asset pool, I do better including it than I do not including it. The figures work out better for my client for it to be in and for me to get a bigger 79 adjustment than if it's out. So just to make things a little bit more complicated, we can run multiple balance sheets to work out the best outcome for the client based on what's been done from an estate planning perspective from their parents prior.
That sounds like a lot of maths for a lawyer, Amanda. I signed up for law because I'm terrible at maths, so I don't envy you that position at all. So I'm sorry for hijacking your slides as well. I've got one more question from Tara, which she's just told me that I can also show the message on the screen, which is just very exciting. Can a TT that doesn't include spouses as beneficiaries help practically with discouraging clients from intermingling assets in their personal pool?
So I think, yes, it can. And can I just say, what I would encourage everyone to do today is when you're preparing your documents from an estate planning perspective, is actually tell your clients that if you get something, do not intermingle it. Tell your children if they get something, do not intermingle it. So my answer is absolutely, you're right, Tara. It can help discourage it because it'll separate it from that and it will become something that's independent automatically. There are benefits to and benefits against the testamentary trust, as you know, and the quality of the person drafting it and their knowledge and skill makes a really big difference to how a testamentary trust is applied and how it's used. But worst case scenario, I always say to everybody doing estate planning, you need to say, if you know that you have a mum comes and sees you and says, my daughter is going through a divorce possibly, and I'm worried about it. You need to make sure that advice is very clear, that if they choose not to use a testamentary trust after you've instructed, like you've asked them to do it and advise them, that they understand that they should tell their child not to intermingle the money under any circumstances, or their child needs to see a family lawyer even before they separate. So it's quite common for me to see people before separation. And during that process, they want to kind of find out what they should do because they're thinking of separating and they're worried, will they be financially secure? And the first thing I always ask them is, you're expecting an inheritance? You're expecting a lump sum or a gift? And if they say yes, possibly, or yes, my mum's ill or my dad is ill, I'll say, just make sure that you do not intermingle that asset. It gives me more flexibility and the ability to deal with it differently and make different types of arguments from a family law context.
Thanks, Amanda. Sorry for hijacking everything there.
Who would practice family law is my question to you. And no wonder
sounds like too much maths.
So now I'm going to move to asset protections and what are BFAs, or the binding financial agreements, and are they a useful estate planning tool? So there's three clear types, which is your prenuptial agreement or your pre-relationship agreement, which is before the parties marry or enter into a de facto relationship. Your cohab agreement, which is basically when the parties are living together. So this is a really interesting one that very rarely gets used, but it can be very good for a cohabitation agreement, especially for people who are like second and third marriages. And I'll take you through what that means as well. And then the postnuptial agreements, which are your binding financial agreements after the relationship breakdown. And one of those things about the postnuptial agreements is that most family lawyers don't really do BFAs post-separation anymore because they're so risky and they get overturned. It's just much safer to do consent orders signed off by the court. You can't get any more security than that. And the only way you can overturn them is a Section 79A application versus a contractual issue with the agreement might actually overturn any post-nuptial agreements. So we tend to avoid post-separation BFAs where possible because we want to give our client as much security as we can. So I'm going to take you through what American prenup is and what we have, which is essentially the kind of document that we use to try to lock assets away. So in this, previously I was talking about this like sliding scale of utility. These documents are really expensive. If your client tells you that they found a family lawyer who will do it for $2,000, tell them to run. These documents, you shouldn't get change out of about 10 grand for them because of the amount of work that's required to actually try to make them bulletproof as possible. They're very complex. A simple typographical error, the wrong section of the legislation, non-consideration of relevant factors could mean the document is overturned. Because it's a contract, the contractual elements are essential, and the case law regularly changes in relation to prenuptial agreements. So the rules regularly change as to what is acceptable and not acceptable in relation to a prenup. In fact, I personally don't do them in-house anymore because the movement and change is so specific. I'll send them to a lawyer who only does prenups, and that's all they do. As in, the firm or the lawyer is a prenuptial lawyer only, and that's their area of specialty, because then I know that there's not going to be any errors. And this is one of the big areas where lawyers are sued, is prenuptial agreements, because they double click a precedent that they bought from one of the precedent providers without fully understanding the risk they take in doing that. So the utility scale. Younger the clients, the less likely a BFA, a prenuptial BFA is going to stay in place or is going to be binding. What I would say is this, is that the ideal client would be a client who is second or third marriage, maybe in their 60s. They both come with the same value assets. They both have a primary place of residence. They both have children from previous relationships. They're either both retired or same earning capacity. There's no need to rely on Commonwealth support pensions. Those are your people that, if you're going to consider a prenup, are the ones that would benefit from a prenup, because the likelihood of a document like that being overturned is much lower than other sectors of society. The section of the society that is very risky is people where there is a discrepancy in earnings. So you have a really high earner and a really low earner, or someone who rely on Centrelink or other government supports. If they were to separate, you may as well kiss your prenup goodbye. People, once you have a child, you may as well kiss your prenup goodbye. So there's a bunch of different things. What they do is they do protect in the short term for younger relationships. So for short periods of time at the beginning of the relationship, they can be useful if someone's bringing in an asset. But what I would say is that they're not the golden bullet or the shield that people hope they were. They're a tool in your arsenal, but they're not the only tool that's going to answer your wishes and hopes that you can lock an asset away. So,
Amanda, in terms of that sliding scale with the youth, if they revisit it regularly, so for example, they do one when they're 21, and this is in the context, let's say of one child receiving a big inheritance or something like that, and then they do it again at 25, and then they separate at 26, is it more likely to be held to be still appropriate because they revisited it, even though they've been together for 6 years?
I wish I could say yes or no to that. But what I will say to you is this, is it also has a lot to do with the bargaining position of the parties. And, there's lots and lots of case law that talks about, people who are being forced into BFAs because they love the other person and they're basically told sign the BFA or not, the relationship breakdown. So I would say that the context of when they're done, so the pre-relationship, the one you're talking about that you would do during the relationship is actually a cohabitation agreement, which is something that you can do partially through a relationship that specifies if you do break up, this is how we're going to divide our assets. The process of trying to set aside a BFA is expensive also. So it sometimes is cost prohibitive depending on the value of the family law pool that you're trying to fight over to set it aside or not. And depending on who you act for, whether or not there's funding available to fund that, because, for example, your litigation lenders who would normally fund a property settlement won't necessarily fund an application to set aside a BFA, which means they have to find private funding to do that. So that can be a prohibitive part of a reason why a document does not get overturned. The answer to that question is really complicated because there is no one answer, and this is the very crux of the issue with family law and how it interplays with estate planning, because you can use your best endeavors in estate planning to protect the assets. And that's exactly what we do. We protect our clients and we listen to their concerns, and we protect the assets from a tax perspective, from a breakup of a relationship perspective for their children. We do our best, but we can't predict in our crystal ball what's going to happen when it does trigger, because it may be 5 years, 10 years, 20 years. And so whatever plan you put in place may no longer be relevant or not useful at the time. And this includes the prenup. So yes, best idea is just to have everything in your arsenal as possible, but it's also important that people understand that it's not foolproof.
So just to summarize, it depends, which I believe is the classic lawyer statement for everything.
Yeah. I'm sorry. I wish I could give you it's just one of those things. I can't say yes, I can't say no. Look, the general consensus with all accredited specialists is with the prenups is that, yeah, they're great to have them, but we all kind of know they're just a piece of paper. Sometimes it's a bit like, when you see those signs saying park here at your own risk, or
I think we've lost Amanda again. She's obviously just dealing with the Wi-Fi issue. While she's out, I did want to say that I think that it doesn't necessarily... Yeah, I've got you back. I'm just saying while you're out that I think that even though we are making fun of it being an it depends moment, it doesn't mean that we shouldn't be doing everything we can as practitioners to put all of those roadblocks in place. That we don't know what way the law is going to change, let alone how things are applied in court scenarios or under some sort of negotiation. It doesn't mean that we don't do our best to put things in place to help protect our clients.
That's right. I think the key is that you understand that no one answer is the correct, no one tool is the total answer, because no one thing you do will protect everything. It's impossible to achieve everything the client wants in one action, and using a series of tools is an essential part of the process. So not, just as an estate planning lawyer, just preparing a will may not be what you actually need. You might need a will, and you might need to see a family lawyer and a series of other actions to actually achieve the closest result as to what the client's actually wanting. So estate planning is actually more than just the preparation of materials. It's consideration of multiple jurisdictions simultaneously to work out, is there more than one way to achieve this, and how can I protect the client across all these different jurisdictions? So the next one we talk about is the cohab agreement. So during relationship, basically it's a contract you enter into while you're together that if you do separate, this is how we're going to separate those assets. It has the same pros and cons as a prenup. So really it's something that if someone comes to you during relationship, second or third relationship, and their kids are giving them a really hard time and they're like, we don't know what to do, and you're doing their estate planning, you could also say to them, look, there's a thing called a cohabitation agreement, which you guys can enter into, which says if you do separate, this is what's going to happen. And then you can try to protect it from an estate planning as well as family law perspective. So just keep that in mind as well. So during the relationship, someone might come to you for their estate planning documents, but you think to yourself, you know what, this family would really benefit from having an outcome that was already agreed if they do separate because of issues internally within that family unit. So just something to think about there as well. Okay, so let me explain the difference between orders and a binding financial agreement. So when parties separate and they reach an agreement for division, you can finalize in two ways. One is a binding financial agreement, which is the contract that we've just talked about, which can be overturned on many different elements. And then there is orders, and orders are done by way of an application for consent orders in terms of settlement. So the first thing I would say is if you see anybody for estate planning and they've not done a formal property settlement, send them to a family lawyer straight away. Even if they're each keeping what they've got or they've only got super, send them to us immediately. And the reason for that is that they can still claim against each other under the Family Law Act, even when statutory limitation periods have expired, if they can show hardship. So sitting on your hands is not the actual answer in family law. Dealing with the elephant in the room is the answer to the question. And then once I can give you security of orders and you've got your divorce, the likelihood of any claims against your estate also drops dramatically as well. So the likelihood of a succession or relevant claim reduces, because it's definitely, the court will take into account the fact that a formal property settlement has been undertaken. So when you're estate planning, if you identify no formal, you should ask your client if they've separated from someone and they're like, we've divided our assets. Actually ask them, do you have orders? Do you have a binding financial agreement? If their answer is no, send them to a lawyer immediately so that we can clean it up and we can make sure that we've secured them from a family law perspective. I'll give you an example. Wasn't that many years ago, I had a lovely client who was in his 80s who came to see me. His wife left him when he was in his 40s, and they'd never done a property settlement, and they had never been divorced. They just went about their separate lives. She came back 40 years later, and she got a full division under the Family Law Act. So what I will say to you is just because people have mutually divided assets doesn't mean it doesn't need to be formalised. So please do that. There is statutory limitation periods. De facto relationships is 2 years post-separation. Divorce is 1 year after the date of the divorce. But the reality of it is that the court considers there's hardship. They'll just open the matter up on leave. So yes, it exists, but the reality is in most circumstances, leave would be granted. It is an interlocutory or interim application that's made first, but the court is likely to consider that the matter should be relisted. So even with your best estate planning, if someone comes and sees you after separation, they still need to do it. It's not really optional. It's part of the estate planning process that a property settlement should have taken place. Hopefully that's kind of clear. So take that from today. It's one of the only black and white rules in family law. Okay, so now I'm going to talk to you about asset protection and forced separation. So does everybody know about Stanford's case? I'm going to say yes. We've got a few thumbs up. Okay, great. All right, so basically Stanford's case is really interesting, and the interplay with estate planning is also extremely interesting. So Stanford's case, basically they were separated due to health reasons, and one person went into a nursing home and the other person stayed in the primary place of residence. Stanford's case is very clear in situations of forced separation that it doesn't actually trigger the Family Law Act unless one party's needs are not being met. So what that is that a lot of people will come and see you for estate planning, and I need to talk to them at the time they're estate planning of what's the plan if one of you needs to go into a nursing home and a RAD is required and one of you won't require that. Are you going to sell the house to fund the RAD? What's the intention? Because in situations such as Stanford's, and this is not an uncommon situation, you might have children who are doing the decision making because they're both quite elderly, and you've got a person that's in a nursing home that's not having their financial needs met, and someone living in a primary place of residence where all the equity is locked up. And we have a problem where one person is not in a good financial position, not being adequately cared for because the assets are locked into a primary place of residence. And Stanford's case talks about the fact if one party's needs cannot be met, then they will consider making a property settlement. So dividing the property pool to accommodate both parties, so enlivening the family law jurisdiction for a property division. And these kind of applications are usually made by someone acting as power of attorney for the person that's actually in a care facility or alike, because it's usually where there's not an intact family unit, so second marriages and things like that, where one parent, like the wife, for example, is in a nursing home and the husband is living in a property, but there's not enough money for both of them. So the children of the wife will make an application and say that it's basically Stanford's case to try to get a property division to peel the assets apart so that they can make financial provision for the mother. So when we talk about estate planning, the importance of this case is you need to have actually discussed with your clients what is the plan if or when one of you is going to need care. Is there an intention to sell the house? Do we need to do something in our power of attorneys in relation to this? Do we need to consider from an estate planning perspective what steps can be taken to make sure both are adequately accounted for or have the financial needs met so that they can have the care that they require? And not everybody has sufficient money for a house and a RAD, as we know. So it's a difficult position when you're dealing with parties with small asset pools or a single primary place of residence and no other assets to determine what they're going to do if that circumstance ever does arise. So I don't know if you've had that, Carrie, but that's something that, I always have to talk to the clients about.
Yeah, we consider it certainly from the power of attorney perspective in that instance. I won't hog your time because I know that we've got 15 minutes left, but it is something that we are aware of that case from an estate planning perspective.
Yeah, it's just something that in family law matters, Stanford's case is like one of the big cases in family law. Like there's a bunch of them. You can name them on one hand, the big the big cases, and this is one of them. And when this case was made in 2012, it absolutely changed the way family lawyers practiced. And one of the things that changed was talking about the enlivening of this jurisdiction in circumstances where the parties aren't actually separated, but they're separated by circumstance, not by choice. And when and if the jurisdiction can be enlivened for that purpose. So it's a very niche and specific area, but it does actually arise quite regularly in circumstances. Usually families can work it out between them, but it does enliven the jurisdiction under Stanford's case, for example, a power of attorney to bring a litigation application for a property division in circumstances where their needs are not being met. So something important to keep in mind in family law as well. So you might say, for example, get a daughter or a son who comes to see you in these circumstances, and they are saying to you, I have this specific issue, and this is where you would say as an estate planning lawyer, well, maybe you need to speak to a family lawyer because it sounds like this is a matter under Stanford.
I've got a question here, Amanda, from Tara. She's certainly listening in today. So Tara said here, if parties enter into a financial agreement, should we add anything into the wills or estate plan to reference that? And should the distribution of assets under the will reflect the financial agreement? I've got a secret suspicion Tara might know the answer to that, but I think she's asking it potentially for the benefit of the group as well.
Oh, well, maybe Tara can answer that one then. So from a family law perspective, I'm going to reverse this a little bit just for a second. So in some of the equity and the family law cases, when there's been some sort of promise made to another party in relation to distribution, wills can get called in for the purposes of evidence. I have seen it happen, especially in, for example, brothers and sister cases where there's, assets being held in trust, or in family law matters. Sometimes the estate planning documents can actually be called in as a form of evidence of the promise the parties made to each other. A binding financial agreement is binding on the heirs, administrators, and executors of the estate. So it is legally a binding document, and it can be used for the purposes of the executors to assert interests. So yes, so essentially the answer to your question is that it does assist with all of those different aspects. And from a family law perspective, if somebody dies during litigation, which is what we talk about a bit later in today, the use of a binding financial agreement that may or may not be in place, if they're already in litigation, if it has or has not been set aside, if a party passes away, there's essentially the use and reference to that document is particularly helpful. Depending on which counsel you brief in relation to your succession applications, your family provision applications, or your relevant ones, everyone seems to have a slightly different preference as to whether or not you include particulars inside your estate planning documents, or whether or not you do it as a separate statutory declaration with copies of the documents that sits in your file but doesn't form part of your estate planning. So my answer to that question from Tara is I think it's useful, but other people may not agree with me. Yes, so someone also wrote, it could be also used against them. Also true. So I think it's a balancing act of, I personally, my preference is that it's all together and bundled so that your estate planning lawyer has all your family information, everything's contained within that material. But counsel I have briefed doesn't like it to be referred to in the actual material, as in your actual wills. They prefer for it to be separate. So there is something to be said for having that information on file. There's something to be said for not having a statutory declaration on file. That's something that I have seen go really well and I have seen go really bad. I don't know about you, Carrie, but I've seen it be really useful, and then I've seen it be an absolute disaster.
It sounds very similar to, we had a training that we had the wonderful Kate Brewer and Michelle Davis up on presenting about documenting testators' intentions, and sounds very similar to how they document those sorts of things. The results, can be good, but then Kate Brewer sort of dropped a bombshell that it's only ever been bad in her books. So it's certainly something that I think there's no definitive answer, and it's all about whether it's appropriate in the circumstances.
So I mean, as an estate planning lawyer, you should automatically ask if there's any of these documents that exist, and if there is, get copies. I mean, that's a no-brainer, and it should be in your safe custody packet that you've got, if you've got a certified copy or scanned onto your file, if you have an electronic copy of the document. Because if the matter does get contested, there is a claim against the estate or any of those things, or someone suggests there was no capacity at the time, and then that will aligns with the BFA that was in place that the parties executed between them and those kind of things, then that will be of definite assistance to the executor of the estate in relation to responding to that claim. And I wish I actually knew the answer as to what is the better option. I've had counsel tell me yes, and I've had counsel tell me no. So I suppose that's also case by case. So just in case it wasn't clear enough again. So for kids, I just wanted to talk to you about one specific thing. I want to talk to about Section 65K of the Family Law Act. So I have come across many lawyers who didn't know this, but the Family Law Act basically says that if there are family law orders in place, the care does not automatically revert to the other parent upon the death of the primary parent. An application actually has to be made for that. There's this assumption that the biological secondary parent will automatically take care. The Family Law Act says it doesn't. And this is an issue I've noticed in relation to a lot of people's will drafting. So what they'll do is they'll give guardianship of a child or children to a third party first without giving it to the other biological parent. And what that actually does is trigger this idea that the intention wasn't that the other biological parent will have care first. So a lot of estate planning lawyers don't even know that this section of the Family Law Act exists. So it literally says that if parties are separated and there's an order that says the children live with mum, if mum dies, dad is not guaranteed the children unless the order says on mum's death, dad is the primary carer. So if it is your client's intention, if she dies, that the kids go to dad, and then if dad's not here, the kids go to grandma, make sure it says to dad, not to grandma, because the way the family court will view it is that it was mum's intention to go to grandma, not to dad first.
Can someone proactively change? So I've had this situation happen twice in the past, maybe 3 months. I've lost 2 terminally ill clients, 2 women who had young children and absent fathers for the large part. They lived with her, obviously. Is there a way that they can proactively get the orders changed so that they can say, if she's not here, it's XYZ?
Absolutely. And I do a lot of this work, believe it or not. So what will happen is someone will come to me saying, I'm terminal, and my mum is going to care and he doesn't really want anything to do with the kids. If we can engage with dad, we will do a set of consent orders, and all 3 parties will sign giving parental responsibility to grandma upon the death of mum. And then we cut out Section 65K. And when mum does die, no one's going to court. No one's litigating because the orders are already there. She has parental responsibility. She can enroll the kids in school. She can get the Medicare card. She can get the passport. She can do whatever she wants because she's got sole parental responsibility. If that doesn't exist, if that's not an option and dad's not on board, we would then commence proceedings, and grandma and dad would be the first and second respondent, and then we would get orders by consent or litigated orders in relation to the children before death. So that can be mitigated absolutely 100%. It is a very difficult emotional process for the client when we do that, but it is the way to secure children's care arrangements without fuss upon the death of the parent. Because I had a matter many years ago where grandma had parental responsibility and she lived with granddad, and grandma died and granddad was served by mum at the funeral with court documents to take the children off granddad, and they had been the children's primary carer for 10 years, and we ended up 3 days later in litigation. So it's something that we could have probably they weren't my client until they'd been served, but had I seen them for estate planning, I would have also said to them, I think we need to also look at the family law aspect of what we can do to put orders in place now.
And this is also very different if the father is present, obviously, and engaged.
Correct. Yeah, correct. So what I would say to you is this, is if you do happen to get somebody who is separated, you need to ask them, are there orders? You need to look at the orders. You need to ask them, do they want the biological parent to be the carer? And if they do, they should appoint that person first. And if they don't, then of course appoint the third party. And if they're terminal, you're able to engage with dad to get him to sign consent orders, great. And if they're not, then you might want to look at litigation, because really what's going to happen is upon the death of the primary parent, usually grandma will take the kids, and then dad will have filed, and it will be excuse the pun, but on like Donkey Kong in the family court as to who gets these kids. And nobody wants that, unfortunately. So I also wanted to just let everybody know about a specialty list in the family court, the FCFCOA, called the critical incident list. So this is a new list that recently just started. The reason I want to bring this up is, even though it's technically and it's not a direct estate planning, it's an estate administration thing. So you would usually get the client on the back end of this. It's still really relevant. So this is a specialty list where, say, for example, you get grandma who has picked up the child because dad murdered mum under a DV incident. This is a specialty list that gives them priority listing. And it's basically when you have care of a child and you're not a parent due to the results of death, including homicide or critical injury. So it gives you the ability to immediately list under this critical incident list. It's a very niche and specific area of family law, and it's only a recently released specialty list, but it's really important for estate planning lawyers to know that if you get someone in the door that's a grandma that has the kids and dad's in jail or mum's in jail because she murdered dad, there's a specialty list for this, as niche and small as it is, and they will get priority listing and they get special allocation and funding. So yeah, it's one of the really interesting things. It's only, I think the list about 12 months ago it was established, and it's a very niche area of law. So just make sure if you identify that this may be a situation for you or your client, that you send them immediately to a family lawyer. So make sure you send them to a accredited specialist, because things like these specific small listings are not necessarily generally known by people who dabble across multiple jurisdictional areas. It's usually people who are like knee deep in family law who would be like, there's a specific list that deals with that, and then they'll identify that list and go down that path. Okay, so the last thing I'm covering with you today in the last 4 minutes is the FCFCOA litigation. So basically how your POAs work in relation to loss of capacity during litigation. So if your client loses capacity in the middle of a family law litigation, or you're assisting grandma who is the power of attorney, for example, for their daughter who's lost capacity, you would make an application for a litigation guardian, which is an interim application. You would attach a copy of the power of attorney as proof, and then all of your medical evidence to show loss of capacity. We recently did one where mum has a disability. It allows her to be able to, run her daily life, but understanding the complexity of a property settlement is really difficult for her because she has very basic understanding of mathematical equations. And so we made an application to NCAT to get a financial management order, and NCAT made it specific to financial family court proceedings. So I have a financial management order for that issue, made an application for litigation guardian, and attached that evidence, and the court appointed grandma as the litigation guardian. So from a family law perspective, you need to also, estate planning and family law interplay, you need to consider, if you in circumstances like that, and someone comes to you saying, my daughter's going through a property settlement, she doesn't really understand what's happening, it might be a situation where you might need to look at, can you use the POA that exists, or alternatively, do you require a financial management order that's specific to an issue for that litigation guardian. The other one is loss of capacity. Just generally speaking, you would use all the necessary tools and make an application to get a litigation guardian to agitate on behalf of the person who has appointed you. And then you've also got when proceedings are actually on foot and somebody passes away during proceedings as well as the ability to make an application for divorce. So there's a case called Mackenzie and Mackenzie, which is a 2013 case, but basically the court allows, as long as you've met the minimum requirements for divorce, so 12 months of separation, a POA upon loss of capacity, to make an application to get that divorce. So you're able to not only undertake a property settlement on behalf of the person, but you're also able to obtain that divorce for them, as long as it's clear that the intention to separate existed prior to the loss of capacity. Mackenzie's case says you can do that. So it's not uncommon for people to separate and then not get a divorce for a period of time because they're putting it off and it's uncomfortable, and then they might lose capacity during that process. So you can use a POA for that purpose. So this is a bit more, and I'm happy to share these slides that you've all got access to them. But basically, this is where Mackenzie's talks about basically that the person had the intention of separating. It's just not separation that's caused by the circumstances of loss of capacity, but an actual intention to separate. And then the loss of capacity happened. Keeping in mind, we can go back to Stanford's. If you do lose capacity and require care, even though you were together, if your care needs are not being met, Stanford's allows you to seek a property settlement, and then you would apply under the power of attorney for a litigation guardian appointment, and then you would agitate for a property settlement under Section 79 of the Family Law Act. Okay, so death after filing property matters. I've got a question saying, if a party dies during litigation, can they continue it? The answer is yes. But here's the problem. A children's matter, obviously that's the end of the litigation, because you can't litigate in relation to spending time or living with if you're no longer here, and then the grandparents would make an application themselves. For property, the answer is yes, but the likely outcome of that significantly changes, because obviously there's no needs anymore. And if something is if you're in the middle of a property settlement and you were making adjustments in relation to future care needs, all of those disappear. So you're basically just fighting to claw through the estate what you can for the beneficiaries that have been selected. So the likely outcome significantly reduces. What I will say to you is this. If the only time that really makes a big difference if there's litigation on foot is if the person who would receive the estate is not otherwise the spouse that they're fighting, because otherwise the court's just going to go, well, what's the point in continuing this litigation? It'll only be if there's children from another or previous marriage and you're trying to put the assets into that will to pass it through the will. So it's one of those things where, yes, you can, but it does materially affect the outcome. When you're in family law litigation, this is a very unpalatable circumstance, but in property settlements, if we're aware that someone is terminal, there is arguments made that they need less of the asset pool because their life expectancy is significantly reduced, and the other party will get an adjustment and get more of the asset pool because they're not terminal. And it's an awful thing that we have to submit, but it does actually happen in cases where I will be like, well, unfortunately, the other party's terminal. I have medical evidence to show they have 6 to 12 months to live. They only have needs for the next 6 to 12 months, and my client is healthy. And so they will receive a large adjustment in their favour under Section 75 too, because their future care needs and their future needs are far higher than the other party who only has a short period of time left to live. Not a very nice submission to make.
No, it definitely does. I don't think anything that we ever talk about in estate planning and family law ends up being happy stories, unfortunately. Just the nature of the area of law. But in terms of that question, though, if anyone wants to take anything offline, please feel free to let us know. Amanda's just said she's kind enough to share her slides with us. Tara's also put a link there to one of our resources as well. Amanda, is there anything else that you wanted to cover off before we head off? I'm appreciating that it's just after 1 now.
No, that's okay. I'm just grateful everyone attended today. Hopefully you learned something new. I think most people are most surprised about the section of the Family Law Act that doesn't automatically revert to the other parent. Most people are pretty shocked when they realise that there's a section that says that. So hopefully you got something from today. Feel free to reach out to me. I love talking to other lawyers. I love spending time discussing things with people. I'm always open to people emailing me and asking questions. Lots of people do. So please feel free to reach out to me at any point.
Excellent. Thanks so much, Amanda, and thanks everybody for joining us. We're looking forward to seeing you all in a month's time for the next Facebook Live. Take care.
Thanks, Kerry. Bye.